Scutts.
Thank you, Your Honor. You're here today in 3 separate cases, all entitled State of Ohio versus Curtis L. Wilder. Those case numbers being 25 CR 001550, 25 CR 001551, and 25 CR 001737. These are 3 separate informations that were all filed on December 26th of 2025. In the 1550 case, there's a 2-count information, 1 count of grand theft of a motor vehicle felony of the 4th degree, and 1 count of grand theft of felony of the 4th degree. In the 1551 case, it is a 3-count information, count 1 being grand theft of a motor vehicle felony of the 4th degree, count 2 being grand theft of a motor vehicle felony of the 4th degree, and count 3 being breaking and entering at felony of the 5th degree. The 1737 case is a 3-count information, count 1 being grand theft felony of the 4th degree, count 2 being grand theft felony of the 4th degree, and count 3 being theft felony of the 5th degree. It's the state's understanding today that the defendant, who is present in open court with his counsel William Watson, will waive his right to indictment in all 3 cases, plead guilty to all the counts in all 3 informations. We would ask at that time to defer sentencing so the pre-sentence report, drug and alcohol evaluation, and victim impact statements may be ordered. There's no sentencing agreement, and that's the state's understanding at this time. Thank you.
Thank you. Mr. Watson, does that sound accurate?
Thank you, Your Honor. May it please the court, yes, that's my understanding of this afternoon's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe on each respective case that all discovery has been provided. I've also had an opportunity to discuss these cases with Mr. Wilder. He is prepared to enter a change of plea by way of information as just outlined by the state. First, on each respective case, Your Honor, by entering a change of plea by way of information, he understands that he'll be waiving his right to have this case presented to the grand jury. He also understands that by entering a change of plea, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. Wilder, were you able to hear what the prosecutor and your lawyer just had to say excuse me, regarding what they believe your intentions are here today?
Yes, sir.
And you know, sir, you could be seated during this time. I don't interpret that as any disrespect. I appreciate that.
Okay.
But it's much easier to be sitting down. It's going to take a little bit of time.
Okay, thank you, sir.
Sure. So you're able to hear what they said?
Yes, sir.
They indicated to the court they believe it's your desire to waive your right to have each of these 3 cases presented to a grand jury, and I'll explain in more detail here in a second what that actually means. And then you're going to plead guilty to the charges in each of these 3 counts, which I will also go over with you to make sure you understand those. We would then defer continued sentencing to a future day to get some evaluations complete, come back on a future day for sentencing, where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the right you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'll ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. All right, let's get started then. How old are you, sir?
56, sir.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
It's not prescribed medication,
I'm
just
sorry?
like Tylenol or blood pressure medicine.
You get blood pressure medication?
Yeah, nothing like, no mind-altering.
I know, well, and that's where I'm going with this, but I still want to know, so what medication do you take like on a daily basis? Blood pressure medication?
Yeah, blood pressure, amlodipine, tamsulosin,
What are those for?
to help use the bathroom. Tamsulosin, amlodipine is for the high blood pressure. Torvastatin,
Is that a cholesterol?
cholesterol.
So hang on a second. So except for atorvastatin, blood pressure medication, was that it?
I believe so.
Okay. And as you were guessing, the reason I asked those questions is to make sure you're not under the influence of anything right now, whether it's illegal drugs or even prescribed medication, that's impacting your ability to understand or appreciate where you are, what's going on. You indicated that doesn't do that. These medications don't do that.
No, sir.
So you're a clear mind right now, you can appreciate your surroundings,
Yes, Your Honor.
and there's no medication that's impacting that. Is that correct?
Yes, sir.
One second. One second. All right. Now, did you receive the information that was filed in each of these three cases? That's the documents. Those are the documents that were filed, which set forth the charges you're accused of committing, what you agreed to plead guilty to. Did you receive those?
Yes, Your Honor.
And you had a chance to look those over?
Yes, sir.
All right. Well, in the first case here, 25 CR 1550, there's two charges. Count one was alleged here in what you're admitting to is on or about August 5th, 2025, in Eastlake, Lake County, Ohio, that you did with purpose to deprive Nicholas Svancara, S-V-A-N-C-A-R-A, the owner of property, being a 93 Chevy C15, that you knowingly obtained or exerted control over that property without the consent of the owner or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle, a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about it?
No, sir.
Now, count two, what's alleged on or about that same day, August 5th, 2025, in Wickliffe, Lake County, Ohio, that you did with purpose to deprive Bernard Giannetti, who is the owner of property, being landscaping equipment, that you knowingly obtained or exerted control over that property without the consent of Mr. Giannetti, who is the owner, or anyone else authorized to give consent. It's further alleged the value of this property was over $7,500, which makes the offense grand theft, a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in regards to count two?
Yes, sir.
Any questions about that for me?
No, sir.
Now, in case 25 CR 1551, there's three counts. First count, again, another charge of grand theft of motor vehicle. This one alleged on or about October 26, 2025, in Willoughby, Lake County, Ohio, that you did with purpose to deprive Gregory Ambrose, who is the owner of certain property, being a 2002 Ford F-350, that you knowingly obtained or exerted control over that property without the consent of Mr. Ambrose, who is the owner, or anyone else authorized to give consent. Property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle, a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it for me?
No, sir.
Count two alleges on or about that same day in the city of Eastlake, Lake County, Ohio, that you did with purpose to deprive Tyler Hart, the owner of property, this being a White Ford E450, knowingly obtained or exerted control over that property without the consent of Mr. Hart, who is the owner, or anyone else authorized to give consent. Again, the property involved here is a motor vehicle, which makes the offense grand theft of a motor vehicle, a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in count two in this case?
Yes, sir.
Any questions for me?
No, sir.
Lastly, count three alleges on or about October 25th, 2025, in Mentor Lake County, Ohio, that you did by force, stealth, or deception trespass in 9391 Mercantile Drive, Unit 5, which is the business for Arch Landscaping, and which is also that address is an unoccupied structure, and you did it with purpose to commit a theft offense or a felony. That conduct constitutes the offense of breaking and entering. It's a felony of the fifth degree. Do you understand what you're charged with and pleading guilty to in regards to count three?
Yes, sir.
Any questions about that for me?
No, sir.
Now, lastly, in case 25 CR 1737, you're charged with three counts. Count one alleges on or about September 28, 2025, in Eastlake, Lake County, Ohio, that you did with purpose to deprive Afrim Bitic, B-I-T-I-C, Afrim is A-F-R-I-M, who is the owner of property, being a black trailer containing a four-wheeler and tools. You knowingly exerted control over that property without the consent of the owner or anyone else authorized to give consent. The value was over $7,500, making the offense grand theft, the felony of the 4th degree. Do you understand what you're charged with in pleading guilty to in count 1 of this case?
Yes, sir.
Any questions for me?
No, sir.
Count 2 alleges the same offense, only that this occurred on September 30th of last year. It occurred in Mentor Lake County, Ohio. The owner of the property involved was Joey Walker. The property was construction equipment. Again, the value was over $7,500. So do you understand what you're charged with in pleading guilty to in this case? This count is grand theft also, felony of the 4th degree. Any questions about that?
No, sir.
Lastly, in count 3, it's alleged on or about October 8th, 2025 in Wickliffe Lake County, Ohio, that you did with purpose to deprive William Snow Jr., who is the owner of property, being a pit bike, tools, tires, rims, and equipment, that you knowingly obtained or exerted control over that property without the consent of the owner or anyone else authorized to give consent. The value of the property in this count is alleged to be over $1,000, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in this case?
Yes, sir.
Any questions about this particular count?
No, sir.
So do you understand the nature of all the counts you're pleading guilty to in each of the 3 cases?
Yes, Your Honor.
Well, before I can accept your guilty plea, then I need to make sure you understand all the rights you are giving up in each of these 3 cases. And these rights I'm going to review with you, they apply to all 3 cases. I'm not going to go over them 3 separate times, but they apply to all 3 cases. If there's anything that applies in one case and not the other, I'll let you know that, but otherwise everything applies to all cases, okay?
Yes, sir.
And in each of these cases, first off, you have a right to have each case presented to a grand jury. So the charges I just read to you in the 3 documents, the 3 documents themselves are called informations. An information is a written charge brought by the prosecutor's office without the cases having been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that meet privately to review evidence in cases to determine whether probable cause exists that a person committed a certain crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward on the charges brought by the prosecutor in each of the 3 informations. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can accept your plea, I need to make sure you acknowledge this here in open court in writing. And I have in my possession here 3 separate documents. They're all called the same thing, a waiver of indictment. There's one for each case, which reflects the specific charges for each case. And it basically summarizes and says what I just told you about the grand jury, and it indicates you want to give up that right. Again, I need to be assured you understand the document and that you sign it here in court. Now, my understanding is before I walked out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Watson, is that accurate? Did you review each of these with Mr. Wilder, go over them with him, answer his questions?
Yes, Your Honor. So for each waiver of indictment, I did read it to my client, explain it to him. He read along with me. He indicated he understood it. He signed each document, and I signed each document in the presence of the prosecutor.
Is that correct, Mr. Wilder? You went over each of those with your lawyer?
Yes, Your Honor.
You understand what they say?
Yes, sir.
Any questions for me about any of them?
No, sir.
And also, your lawyer represented that you signed each document. Did you in fact sign each one?
Yes, sir.
And you witnessed that too, Ms. Cutts, each of them?
Yes, Your Honor.
Very well, then at this time the court will make each of those 3 documents part of the record in their respective file. And at this point, Mr. Wilder, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you first of all have a right in each case to have a trial. Now, a trial could be to me as a judge where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty, but you also have a constitutional right to have a jury trial. And a jury trial can be in front of 12 citizens here from Lake County who listen to all the evidence each side wanted to present. The jurors consider and weigh all that evidence, then those jurors make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each respective charge. You understand that?
Yes, sir.
You understand that by pleading guilty, you're giving up your right to have a trial in each of these cases?
Yes, sir.
Now, if we did have a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all the charges, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, I speak of this burden of proof since this is a criminal case. The burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof there is in our justice system. What it actually means it's the amount of the evidence and the quality of that evidence the state has presented at trial to prove you guilty. So in this case, the state has presented evidence to prove each element or each part of all the charges beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, hey Stan, is there something open that side? Now, as I was saying, in order for the state to attempt to prove you guilty, they will be bringing witnesses into the courtroom to testify for the state. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He can ask them anything he wanted to, within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. You understand that?
Yes, sir.
You realize you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You can choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
Very well. Do you understand all these rights we've just discussed then? These are all the rights you have and all the rights you're giving up by pleading guilty. Understand them all?
Yes, Your Honor.
You still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, let's start with case 25 CR 1550. Pleading guilty to the grand theft of a motor vehicle and grand theft. Both of those are felonies of the fourth degree. Felonies of the fourth degree are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, since there's two separate charges here, separate victims, separate crimes, if I did impose a prison sentence, I would impose a prison term on each count. Then as the judge, I would have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together, that you serve them at the same time, whereas consecutive means one after the other. You serve the prison term for count one first, finish that, whatever it is, and then serve the prison term for count two, whatever that may be. Do you understand the difference there?
Yes, sir.
So in this particular case, if I impose the maximum sentence on each count and ran them each consecutive, you're looking at 36 months maximum prison term for this count, for this case. Do you understand that?
Yes, Your Honor.
All right. Now, in case 25 CR 1551, you're charged with 3 counts. Counts 1 and 2 are, again, grand theft of a motor vehicle. Each felony is of the fourth degree. Each of those are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in the range of 6 to 18. Do you understand that?
Yes, Your Honor.
Count 3 is the breaking and entering charge. It's a felony of the fifth degree. That is punishable by a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
And again, I would have discretion as judge if a prison term is imposed to run the prison terms on each count concurrent or consecutive. if I ran them consecutive and gave you the maximum sentence, the maximum penalty in this particular case would be 48 months or 4 years in prison. You understand that?
Yes, sir.
Lastly, in case 25 CR 1737, that case you're charged with 3 counts also. Counts 1 and 2 are grand theft, felonies with 4th degree, each punishable by a possible term in prison of a minimum of 6 months, maximum of 18 months, again, already numbered in the range of 6 to 18. You understand that?
Yes, sir.
Count 3 is a charge of theft. It's a felony of the 5th degree, and it's just punishable by a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
In this particular case, again, if I impose the maximum sentence on each count and ran them consecutive, and I don't have to, I don't even have to impose prison, but if I did that, I need to make sure you understand the maximum sentence you're facing. It would be 48 months in prison in this case. Do you understand that?
Yes, Your Honor.
Now, when we get to sentencing, we're going to sentence, there's going to be one sentencing hearing for all 3 cases at the same time. And as I explained for each particular case, I can run each count within each case concurrent or consecutive. I can also do that with each case. I can run if the prison term is imposed in each case, run the prison term, the overall total for each case, concurrent or consecutive to the overall total for the other cases. You understand that?
Yes, sir.
So in this particular case, with all 3 cases, which you'll be sentenced to at the same time, if I gave you the maximum sentence in each count, ran everything consecutive to each other, and the cases consecutive to each other, you're looking at a maximum possible prison term with all 3 counts of 11 years in prison. You understand that?
Yes, sir.
Now, do you have any other charges pending against you right now? You have charges in Cuyahoga County? Or did you?
Yes, sir.
Are they pending right now?
Yes, sir.
So you haven't been found guilty or pled guilty to anything there yet?
No, sir.
What about anywhere else?
I have one, I think it might be F5 in Summit County.
Okay. Are you currently serving a prison term right now?
No, sir.
Okay. Are you on probation, or were you on probation or any type of post-release control, supervision when any of this happened?
No, sir.
Okay. The reason I asked about the other cases, and I thought it's going to be applicable here, but if you happen to be sent to prison on other cases before you come back here for sentencing, I could run a prison term in any of these cases concurrent or consecutive to a prison term that's already been imposed. But it has to be already imposed. It can't be some future possible sentence. I can't say my sentence is consecutive to a prison term in Cuyahoga if he gets sentenced to prison. I can't do that. It's already got to be imposed. It doesn't sound like that's going to be the case here, but I want to make sure you understand that. You understand that?
Yes, sir.
Okay. Now, if a prison sentence is imposed in any of these cases, upon your release from prison, you could be placed on what we call post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And in each of these 3 cases, that could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were put on post-release control in any of these cases, and you never violated any of the conditions of your post-release control, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in each of these cases. Case 25 CR 1737, that's 3 counts. You could be fined up to $5,000 on each charge of grand theft, $2,500 on count 3, the charge of theft, for a maximum fine in this case of $12,500. Do you understand that?
Yes, sir.
In case 25 CR 1551, there's 3 counts there as well, and that also carries with it a possible fine of $5,000 on counts 1 and 2, $2,500 on count 3, the breaking and entering charge, for a maximum possible fine in that case of $12,500. Do you understand that?
Yes, sir.
Lastly, in case 1550, 25 CR 1550, I could fine you up to $5,000 on each count. There's 2 counts. So that's a total possible fine of $10,000. Do you understand that?
Yes, sir.
So with all 3 cases, a possible maximum fine of $35,000. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable with any of these cases. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution if that's applicable in any of these cases for any economic loss any victim may have suffered as a result of your criminal conduct. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory with any of these charges. In each case, and all the charges in each case, you are eligible for probation, what is called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I would consider that if that's what you were asking for. I would look at all the information presented to the court, then I make the decision I thought was the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control, in any of these cases, it could be up to 5 years. As a judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you ever are on community control sanctions in any case and you violate the conditions of your community control, we would have a hearing to see if you're what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. It would be it could be up to the amount of time I previously explained to you in each case. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face in any of these cases?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time in these cases to talk about them with your lawyer, have him review the reports with you, discuss issues, and answer whatever questions you may have?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering this guilty plea freely and voluntarily?
Yes, sir.
All right, do you have any questions for me at this time then, Mr. Wilder, regarding anything we've just talked about, the rights you're giving up, any of the penalties you face, the charges you're pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer?
No, sir.
All right, then what's going to happen at this point, the prosecutor here, she's going to explain for me, we'll do one case at a time to make it easier, what the evidence in each of those cases would be if we did have a trial. I want you to listen to her, because I got some follow-up questions for you about that, all right?
Yes, sir.
All right, Ms. Cutts, let's start with, what do you got, 1550, I guess? What's going over that way?
Yes, Your Honor.
Okay.
Had this matter proceeded to trial in 25 CR 001550, the state would have proven beyond a reasonable doubt that on August 6th of 2025, just before 7 a.m., Eastlake Police Department was dispatched to an address on Lakeland Boulevard in Eastlake County, Ohio, to investigate a grand theft auto complaint. They spoke with Nicholas Spanpara, who indicated that his 1993 Chevrolet pickup truck was stolen from the front parking lot of 35300 Lakeland Boulevard between Monday morning and that Wednesday morning. He described his vehicle with the hood ornament and specific details of it, including its green coloring. Officers reviewed flock camera and saw the vehicle leaving the basic area on August 5th, 2025 at approximately 10:40 p.m. While this was going on the same date, August 6, 2025, shortly before 8 a.m., Wickliffe Police Department officers responded to Gianetti Landscaping on Lloyd Road in Wickliffe, Lake County, Ohio for a theft. They spoke with Bernard Gianetti, who indicated that 3 of his landscaping trailers had been broken into the night before on August 5th of 2025. All of them had been locked, but the latches had been cut. Blowers, chainsaws, trimmers, pole saws, pole trimmers, and more equipment and tools were taken out of the 3 trailers. The value was over $10,000. There was a company nearby that had cameras. They were able to view the cameras and see a Chevy truck pull into the location at 10:55 p.m. on August 5th and then pull out around 11:22 p.m. Checking flock camera, they were able to get the license plate and find out that that vehicle had been reported stolen just that morning in the Eastlake report. So that was Mr. Nicholas Van Carr's vehicle that was being used in the theft. Wickliffe began to do additional investigation and noticed that in the flock cameras that a black GMC truck was in the same location for the Wycliffe theft. They also looked at flock near the East Lake theft of the other motor vehicle and found that that black GMC truck was there as well. They were able to get the license plate, they ran it, and found out that that black GMC came back to Curtis Wilder, the defendant. As investigations continued, Wycliffe was able to get cell phone data and was able to place the defendant's cell phone as well as his truck from flock at Gianetti's Landscaping during the time of that theft, as well as in Eastlake at the time of the vehicle theft. Eventually, a warrant was obtained by Wycliffe. Willoughby Police Department actually arrested the defendant. He had his vehicle on him at the time, as well as the phone. He took the police to 2 locations and recovered other vehicles unrelated to these cases. Neither Mr. Gianetti nor Mr. Svancara gave permission for the defendant to take their vehicles and or their equipment. All of this occurring in Lake County, and that would have been the initial evidence.
Very well, Mr. Wilder, were you able to hear what the prosecutor had to say regarding what she believes the facts would show in case 25 CR 1550?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then. Regarding count 1, charging with grand theft of a motor vehicle, felony of the 4th degree, what is your plea to that count?
Guilty.
Regarding count 2, charging with grand theft of felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
All right. Ms. Cutts, let's move on to 25 CR 1551.
Your Honor, if we want to go chronologically, it might be better to do 1737.
Okay, it's fine.
Had the matter proceeded to trial in 25 CR 1737, the state would have proven beyond reasonable doubt that on September 29th of 2025, at approximately 7:30 a.m., Eastlake Police Department officers were dispatched to an address in a business at East 367th Street in Eastlake, Lake County, Ohio, for a potential theft. They spoke with Afram Biddick, who indicated that when he arrived at work that morning, his black enclosed trailer had been taken from the parking lot. It did have an AirTag in it, and he indicated that the last location he was seen at was just after midnight on Manor Avenue in Cleveland, Cuyahoga County. Officers reviewed flock and saw the vehicle at approximately 11 p.m. on flock. Officer was able to recover the trailer on East 87th Street later that afternoon based on the AirTag pings as well as flock. Inside that trailer that was taken, besides a few other tools and items, was a 4-wheeler. Eastlake Police Department was later made aware that Mr. Biddick believed that his 4-wheeler was on Facebook Marketplace. Following through that investigation, it was learned that the 4-wheeler was at 2988 Martin Luther King Drive. Officer was later able to speak with the individual at that location who indicated he had purchased the 4-wheeler from Curtis Wilder, the defendant, and that it had been delivered to him in a large black enclosed trailer. That 4-wheeler was recovered at that time. On October 3rd of 2025, shortly after approximately 8:30 a.m., Mentor Police Department was dispatched to take a report on post of a theft at Walker Roofing and Construction located on Pinecone Drive in Mentor Lake County, Ohio. Joey Walker indicated that on September 30th, 2025, shortly after 10 o'clock, somebody had broken into his company's enclosed trailer and stole tools and equipment out of it. The metal attachment closing the trailer had been cut. He did have trail cameras which showed a black pickup truck coming to the location. Some of the items that were taken from the trailer included finish nailers, saws, blades, cordless drills, multi-tools, blowers, sanders, saws. All of the items were determined to be over $15,000 in value. Through flock cameras as well, through cell phone data, the defendant's phone was found to be located at that location in Mentor as well as in the previous location in Eastlake. And on October 9th of 2025, just before 5:30 p.m., Wycliffe Police Department was dispatched to a business in Wycliffe, Lake County, Ohio, where a trailer had been broken into. The evening before on October 8th, 2025. William Snow Jr., who the owner was spoken to, he indicated that his trailer had been damaged and various items had been taken out of it, a blue pit bike, generators, jacks, helmets, other equipment, and tools over $2,800 in value. The latch to the keypad had been broken and it had been pried open. There was video showing a black GMC truck, and the male was seen wearing a ski mask. Flock confirmed that this vehicle was the defendant's and was in the area on October 8th of 2025, arriving as well as leaving shortly thereafter. Defendant's vehicle was found to be in that location at that time, as well as cell phone data placement at that location. All of this occurring in Lake County, Ohio, and that would have been the evidence in 1737.
Thank you. Mr. Wilder, we're able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we did have a trial in this particular case?
Yes, Your Honor.
And what, if anything, do you have to say about these facts as she presented them? Are these facts true? Did you do what she said?
Yes, sir.
Very well then, regarding counts 1 and 2, each charging with grand theft, each felony is with fourth degree, what is your plea to each of those two counts?
Guilty, Your Honor.
Regarding count 3, charging with theft, the felony to fifth degree, what is your plea to that count?
Guilty.
All right then, Ms. Cutts, let's go to 1551.
Thank you, Your Honor. At this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 25th of 2025, shortly before 9 p.m., Mentor Police Department officers were dispatched to Arch Landscaping at 9391 Mercantile Drive in Mentor, Lake County, Ohio, for a breaking and entering. Officers were able to speak with Mitchell Archibald, the owner, by phone. He was able to watch some of the cameras from his location and indicated it was a black GMC truck. Officers saw the door on the west side of the building had significant signs of forced entry, and the camera showed that two masked individuals used a crowbar to force entry. An employee came on scene and did not find anything specifically broken. There were paint samples taken from the door as well as tool marks. The Mentor Police Department was able to receive a pry bar that Whitcliffe Police Department had gotten from the defendant's vehicle when they had taken his vehicle into custody, as well as a receipt from Home Depot showing the purchase of a pry bar and two masks. Video was able to be obtained from Home Depot showing the defendant purchasing the yellow pry bar as well as the masks. The paint on the pry bar was found to match the paint at Arch Landscaping on that door, as well as flock cameras put the vehicle in the location and cell phone data put the defendant's cell phone in that location. On October 27th of 2025, just after 7 a.m., Eastlake Police Department was dispatched for vehicle theft on East 361st Street in Eastlake, Lake County, Ohio, Hart Masonry and Stone, where they spoke with Tyler Hart, who indicated that his work truck was stolen on October 26th around 8 p.m. He had Ring cameras showing a black pickup truck. The vehicle of his that was stolen was a 2007 white Ford box truck E450. Flock found the GMC vehicle connected to or registered to the defendant, Curtis Wilder. When Whitcliffe obtained a warrant and the defendant was arrested on October 28th, 2025 in Cuyahoga County by Willoughby Police Department, he gave information that directed the Willoughby Police Department officers to the location of that white box truck, and that vehicle was recovered. Cell phone data placed the defendant's phone at that location, as well as flock cameras placed the vehicle. On October 27th of 2025, shortly after 7 a.m., Willoughby Police Department officers responded to the Ambrose Company located on Code Avenue in Willoughby, Lake County, Ohio for a theft report. Officers spoke with Greg Ambrose, the owner, as well as an employee, Anthony George, who indicated that a 2002 white Ford F-350 with a black flatbed had been stolen from the location, as well as a 2022 white 16-foot box trailer. The trailer contained numerous tools, including generators, saws, wheelbarrows, totaling over $60,000 worth of equipment. They had video, or a neighboring company had video, showed the black GMC truck. When the defendant was arrested by Whitcliffe, due to a Whitcliffe warrant by Willoughby Police Department on October 28, 2025, the defendant showed the officers, or directed the officers, to where the truck was located. So the truck that was taken was recovered. The other items were not at that time. Defendant did allow access to his phone, which showed some of the equipment that had been stolen. He had photographs of the equipment on his phone. Glock placed his vehicle at the location. Additional cameras from businesses in the area showed the black GMC at the location. Based on additional investigation, it was believed that some equipment may be at an address on Manor Avenue in Cleveland, so a search warrant was obtained and executed where the individual indicated at the house that Mr. Wilder had brought equipment there to ask to store it and then had returned the next day on the 27th of October with a U-Haul to pick up the property. 2 items had been left behind, a blower backpack and a handheld pump. Those were later identified as items that were stolen from the Ambrose Company. U-Haul rental center was looked into. It was determined that an individual had rented the vehicle and the second person was on the transaction, that being Curtis Wilder. All of this occurred in Lake County, Ohio, with the thefts, and that would have been the state's evidence in these matters.
Mr. Wilder, are you able to hear what the prosecutor had to say regarding what she believes the evidence would show in 25 CR 1551?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are those facts true? Did you do what she said?
Yes, sir.
Very well, then, regarding count 1 and 2, charging with grand theft of a motor vehicle, each felonies of the 4th degree, what is your plea to each of those 2 counts?
Guilty, Your Honor.
Regarding count 3, charging with breaking and entering, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time 3 documents. They're each called written pleas of guilty and judgment entries, which explain everything I've just gone over with you. Before I can accept your plea in each of these cases, I need to make sure you understand each of the documents and that you sign them here in open court. Now, my understanding is that before I walked out here, you had a chance to go over these documents with your lawyer. Is that correct?
Yes, sir.
Mr. Watson, is that accurate? Did you review these with Mr. Wilder?
Yes, Your Honor. I reviewed each written plea of guilty form with Mr. Wilder. I read them to him. He read along with me. He indicated he understood it, and he signed each document, and I signed each document in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Wilder? You understand what these documents say?
Yes, sir.
You did go over them with your lawyer?
Yes, sir.
Do you have any questions for me about any of them?
No, sir.
It also does appear that you signed each of these documents as well. Did you in fact sign each of them?
Yes, sir.
Mr. Watson, you witnessed that?
I did, Your Honor.
Ms. Cut, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. And in case 25 CR 1550, find the defendant guilty of count 1, grand theft of a motor vehicle, felony of 4th degree in violation of 2913.02A1, as well as count 2, grand theft of felony of 4th degree in violation of 2913.02A1. As for case 25 CR 1737, I'll accept the defendant's plea and find the defendant guilty of counts 1 and 2, each grand theft, each felony of the 4th degree, each in violation of revised code section 2913.02A1. He will also be found guilty of count 3, theft of felony of the 5th degree in violation of 2913.02A1. Lastly, in regards to case 25 CR 1551, I will accept the defendant's plea, find him guilty of count 1 and 2, grand theft of a motor vehicle, each felonies of the 4th degree, each in violation of 2913.02A1, and count 3, breaking and entering, a felony of the 5th degree in violation of revised code section 2911.13A. In each of these cases, I'm going to refer the first sentencing order, pre-sentence report investigation, victim impact statement. Bond will be continued at $500,000 cash surety in 25 CR 1551. Bond will remain revoked in case 25 CR 1550. And in 25 CR 1737, I'm going to set bond at $10,000 cash surety. Is there anything else for the record at this time, Ms. Cutts?
Just so everything is clear, on 1737, that is a case that was a secret information, so you have a document for him to
Do I have that?
be booked in. Yes, should be attached to that packet.
Oh yeah, it is. I got it. Okay. Yeah, I get this to the sheriff's department so that they know to book him in on this case. He hasn't been booked in on this case, so that will need to happen there. One of these get filed too, but. Anything else, Ms. Cutts?
No, thank you, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All rise.
All right, now listen, I'm going to